Hello everyone, today I will share with you information about the options to get U.S. citizenship for your child. U.S. citizenship for children. U.S. citizen or immigrant parents have three options to get citizenship for their child. Options number 1, acquisition of citizenship. Naturalized U.S. citizens share equally in the rights and privileges of U.S. citizenship. U.S. citizenship offers immigrants the ability to vote in federal elections, travel with a U.S. passport, run for elective office where citizenship is required, participate on a jury, become eligible for federal and certain law enforcement jobs, obtain certain state and federal benefits not available to non-citizens, obtain citizenship for minor children born abroad, and expand and expedite their ability to bring family members to the United States. If you are a U.S. citizen or immigrant parent, figuring out how to help your non-citizen child gain citizenship can be confusing. The U.S. immigration laws have not been particularly kind, mainly because the basic requirements for seeking citizenship for children have changed so frequently during the past 50 years. Fortunately, things are not as complicated as they might look. The immigration laws provide for three main mechanisms that a U.S. citizen or immigrant parent can use to seek citizenship for their child, birth outside the U.S. to U.S. citizen parents. It's called the acquisition of citizenship. Citizenship or naturalization of parents. After the child has obtained a green card in the U.S., it's called the derivation of citizenship and also application for citizenship under Section 322. Acquisition of citizenship at birth. If you or your spouse or both are United States citizens and your biological child was born abroad, your child may automatically acquire U.S. citizenship and will not need to apply for citizenship. Unfortunately, this law does not apply to adopted children. The law requires that the U.S. citizen parent or parents have been physically present or resided in the U.S. for certain amounts of time prior to the birth of the child in order for U.S. citizenship to automatically transmit to the child. The amount of time of physical presence or residence varies, depending on when the child was born, due to changes in the law over the years. For purposes of this article, we're assuming that your child was born recently, within the last 18 years, or will be born soon. Congratulations! Just be aware that if your child was born prior to November 14, 1986, different requirements will apply because the law in place before that date was different. Subscribe to our channel and get more information from our next video. The law also requires different periods of physical presence or residence depending on the immigration status of the parents. If both parents are U.S. citizens prior to the birth, the parents must simply show that one of them had resided in the U.S. or one of the U.S.'s territories at some point. But if only one parent is a U.S. citizen and the other is a U.S. national, the U.S. citizen parent must show physical presence in the U.S. or a U.S. territory for at least 1 year. If the non-citizen parent is an alien or foreign national, the U.S. citizen parent will have to show physical presence for at least 5 years, 2 of which were after the U.S. citizen parent turned 14 years of age. To confuse you even more, the U.S. immigration law also provides for differences for children born out of wedlock. That is, if your parents were not married while you were born, the laws of the time may refer to you as illegitimate, meaning in legal terms that you have no recognized father. As you will see in the sections below, your right to claim citizenship may depend on you providing evidence that your father took the actions necessary to satisfy the legitimate law of your birth country. Legitimation laws require fathers to legally acknowledge their children. Again, for the purposes of this article, we are assuming your child was born relatively recently or will be born soon. Subscribe to our channel and watch our next video if your situation is different. If a child was born out of wedlock after December 24, 1952, and the mother was a U.S. citizen, the mother must show at least 1 year of physical presence in the U.S. or a U.S. territory. If the only U.S. citizen parent of a child born out of wedlock was the father, however, the law is much harsher. To prove that the child acquired citizenship, the father must show, by clear and convincing evidence, that the father and the child have a blood relationship, that the father was a U.S. citizen at the time of the child's birth, that he will provide financial support for the child until he or she turns 18 years old, and that the father-child relationship will be legitimated or legally recognized. The father will still have to demonstrate some period of physical residence or presence in the U.S. or its territories. Generally, people are born U.S. citizens if they are born in the United States or if they are born to U.S. citizens if you were born in the United States, including, in most cases, Puerto Rico, Guam, and the U.S. Virgin Islands. You are an American citizen at birth, unless you were born to a foreign diplomat. Your birth certificate is proof of your citizenship. The citizenship acquisition laws can be complex. For more information, subscribe to our channel and watch our next video, Automatic U.S. Citizenship for Children by Birth to Citizen Parents, to learn more about acquisition of citizenship.